Justice Breyer's opinion in Comstock at least seems to give us some kind of test to apply to necessary and proper clause questions. It's unclear what to make of the Comstock test, however, in light of the Court's 2012 decision in NFIB v. Sebelius, the Obamacare case. We'll also discuss this case when we consider the modern commerce power and the taxing power. Obamacare, of course, was one of the big issues in the 2016 presidential election and remains a central political dividing line. The basic premise of Obamacare was that most Americans should be required to have health insurance. A primary economic rationale for this claim is based in externality theory. I always tell my students that they must learn something about externality theory in order to become well-educated lawyers. So, here you go. Let's say Abel wishes to purchase widgets from Baker. Our baseline assumption, all other things being equal, is that the buyer and seller, Abel and Baker, are in the best position to establish an efficient price for this transaction. Baker knows what it cost him to make the widgets. Abel knows what the widgets are worth to him and what he is willing to give up to buy them. Abel and Baker therefore can negotiate a contract for this transaction. Over time, other suppliers may offer widgets at competing prices, and a competitive market will develop. Suppliers may also begin to innovate with different widget designs or with alternative products to compete with widgets. From an economic perspective, the primary role of the law in this simple example is to provide stable rules for property and contracts, which allow the efficient private market to flourish. The setting of prices based on supply and demand accounts for all the costs and benefits of widget sales. But let's say Baker's method of manufacturing widgets involves the creation of air pollutants. The air pollutants affect Kane, who lives in a house near the factory. Kane's health is damaged and the value of her home is lowered because of the pollution. Now there's a cost external to the transaction between Abel and Baker, which is not captured in the price Abel pays Baker. This is an externality. The market is not really efficient because Abel and Baker are imposing costs on Kane that are not reflected in the underlying transaction and for which Kane receives no benefit. Here, it can make economic sense for the law to step in and require Abel and Baker to internalize the externality. If Baker is fined under an environmental law restricting pollution emissions, for example, that cost will be passed on in the price to Abel, and the social cost-benefit equilibrium will be restored. If the cost of a fine is high enough, it might be cheaper for Baker to relocate the factory or to innovate less polluting methods of manufacture. In addition to regulatory fines, the law can compel parties to internalize externalities through taxes, tort liability, and other means. These direct means of legal regulation, in turn, incentivize private actors to spread the risk of liability through insurance. Insurance provides a safety net both to the regulated entity that might face liability as well as to an injured party who needs compensation for harm. And because insurers want to keep their costs down, the insurance underwriting process improves compliance. The example of air pollution relates to negative externalities. A transaction can also produce positive externalities. For example, many cars today come with sophisticated accident avoidance systems. A buyer might be willing to pay a premium for a car with such a system because the buyer's own property and life is less likely to be damaged by an accident. At the same time, the buyer's car is less likely to damage another driver's property or life. This means the cost the buyer incurs for this extra safety measure benefits both the buyer and others, a positive externality. While negative externalities suggest a need for government penalties, taxes, or liability, positive externalities suggest an economic case for a public subsidy or mandate. The government might defray some of the private costs of a collision avoidance system through a subsidy, or it might mandate that all cars manufactured after a certain date must employ such a system. The overall cost is spread across the public through taxes, a form of public insurance. Public health entails significant externalities because all of society bears a cost whenever anyone's health is compromised. This includes costs of lost productivity, contributions to care made by family members and others, the spread of infectious diseases, and other social costs. Inadequate health care produces negative externalities, while good health care produces positive externalities. This presents an economic case for government intervention in healthcare markets. These are not the only economic concerns regarding public provision of health care, and of course there are also moral concerns, but economic theory is a useful lens for approaching the issue. In some countries, government intervention takes the form of a largely government-run healthcare system. In the U.S., for various historical and political reasons, a government-run system has not been an option. Instead, the U.S. system has been a kind of hybrid, or mutant if you want to tweak the metaphor a bit. A heavily regulated private healthcare market funded through a heavily regulated private insurance system funded largely by employers that supply health plans as an employee benefit along with expensive private plans, supported by a safety net of public insurance for low-income people, Medicaid, and older people, Medicare. This system left a substantial gap of about 45 million people who did not qualify for Medicaid or Medicare, were not covered by an employer-sponsored plan, and did not purchase a private plan, including many people who were self-employed, worked part-time, or worked for companies that did not provide insurance. Obamacare sought to plug this gap by requiring nearly everyone without health insurance to purchase an insurance plan or to pay a shared responsibility payment. It also established a state exchange system to facilitate the market for private health plans. As mentioned, individuals had the option to purchase a private health insurance plan prior to Obamacare, but such plans usually were very expensive. Part of Obamacare's reasoning was that as more young, healthy people purchased private insurance, the laws of competition would drive down prices and it would become more affordable. The shared responsibility payment was supposed to provide an incentive to jolt this process into action. You should notice that the shared responsibility payment is similar to the kind of penalty or tax regulators often employ to deal with externality problems. In addition to these parts of Obamacare, the law also provided an incentive for states to participate in the exchanges. If any state failed to participate, it would lose all of its federal funding under the Medicaid program. As you probably know from following the news in recent years, the requirement for individuals to have health insurance or make a shared responsibility payment to the government was like a match on gasoline in our culture wars. Conservatives saw this as a gross expansion of federal power over individual liberties and over the ability of state governments to manage their own health care markets. Liberals saw it as a signature social justice achievement of the Obama administration. One of the interesting things about the Sebelius case is the way in which this broad, polemical public policy debate translated into fights over constitutional doctrine, in particular over federalism doctrines. When we discuss the taxing power in Unit 5, we'll see that the courts, or perhaps more accurately Justice Roberts' classification of this payment as a tax rather than a penalty, made all the difference on federalism grounds, even though it makes no difference in economic terms. But now let's look at how the federalism question played out under the necessary and proper clause. The alignment of the various justices in Sebelius can be confusing, particularly because we're reading the case in excerpted sections. The first issue in the case was a procedural question about the Anti-Injunction Act, which the court unanimously agreed did not bar the case from proceeding. On the substantive federalism issues, for the portion of the case we're reading in this unit on the necessary and proper clause, there was no majority opinion. Justices Roberts, Scalia, Thomas, Alito, and Kennedy ultimately agreed that the individual mandate was improper under the Commerce Clause and the Necessary and Proper Clause. However, Scalia, Thomas, Alito, and Kennedy disagreed with Roberts on the Taxing Clause issue. Remember that Kennedy has been a key swing vote who often aligns with conservatives on economic issues. This case produced the odd result of Roberts swinging to the liberal side on the taxing power issue. Meanwhile, on the question of whether the Medicaid penalty against states violates the spending clause, Roberts remained with the conservatives, who were joined by Justices Breyer and Kagan from the liberal wing to invalidate a provision that would completely withdraw Medicaid funding from states. However, Roberts swung back with the liberals to hold that this provision was severable from other parts of the law that required states to expand their Medicaid programs. You don't have to sort all this out now. We'll come back to it when we talk about the contemporary commerce power and the taxing and spending powers in Units 4 and 5. For now, let's return to the focus on the necessary and proper clause opinions. Some questions to ask yourself that we'll discuss in class. How is the necessary and proper clause employed in these opinions? What value, if any, are these opinions as precedent in future necessary and proper clause cases? How do the opinions written by different justices on the issue relate to their views of federalism and of constitutional interpretation? How, if at all, do the opinions in Sebelius relate to Thornton or Comstock?